Hi, I'm Nikki Jovicic from Lookupstrata, and I'm recording this chat today with Warwick van Ede, lawyer from JS Mueller Co Lawyers. This session is concerning a recent smoking and smoke drift decision in New South Wales and what it means for you in your building. We're recording this on the 24th of February 2022. Before we begin, I'd like to mention that the information contained in this session is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in this session. Warwick wrote an article which you may have seen on the Lookupstrata site. It appeared in our newsletter a few weeks ago, and it concerned a recent NCAT decision recognising that even though a lot owner smokes inside their lot, they still may be in breach of the bylaws of the owners corporation and leave themselves open to penalty. Warwick, could you give us an overview of the case and why it's important to New South Wales owners corporations and residents, both the smokers and the non-smokers?
Sure, Nikki. Yeah, thanks for having me. This was a case which related to a multi-storey residential building in Sydney's CBD. I think it's about 20 stories in height. And the respondents in the proceedings were lot owners who smoked regularly inside their lot and on their balcony. And they thought that was okay because the bylaws of the owners corporation said that you couldn't smoke on common property or allow smoke to penetrate common property. And they thought if they were smoking in their lot and blowing it out their window or standing on their balcony and puffing off into the air, that was okay. Unfortunately, the neighbours next door continually had smoke drifting into their apartment around through the airspace, through their windows, through their balcony doors, onto their balcony at all hours of the day and night. And so the owners corporation said, we really need to test this out. And so they brought proceedings against the smoking occupants on the basis that those occupants had breached the bylaw, and they sought a penalty from the New South Wales Civil and Administrative Tribunal, as well as orders that those persons cease smoking on their balcony and in their lot. Now, the tribunal found that the act of puffing smoke into the air surrounding the building and that having penetrated into the next door neighbour's apartment was a breach of the bylaw, because even though the next door neighbours were inside their lot when they smelt the smoke, the tribunal agreed with our argument that in order to get into the next door neighbour's apartment, the smoke had to travel through common property airspace and then through a common property window and through a common property balcony door. And so in that way, the smoke penetrated common property. The smoking occupants tried to argue that in order to apply, that bylaw meant that you had to be standing on common property and smell the smoke. The tribunal said, no, it doesn't need to be that. You can be within your lot and smell the smoke. And we agree that the smoke will have had to travel through common property airspace in order to reach that adjoining lot. So even that bylaw, which was fairly broad in the way that it was drafted and mirrors to some extent the standard bylaw under the 2016 regulations, allows an owners corporation to take action against smokers if the smoke is penetrating into other lots or common property. So it has broadened significantly the ability of owners corporations to be able to take action against smokers where they're causing a nuisance to other lot owners and occupants.
And I guess what smokers and non-smokers and owners corporations are thinking about this decision is, now that the decision's been made in NCAT, is smoking banned in Strata?
Well, it's not banned, and there was actually another decision of the tribunal, which goes back to 2019 now, which is known as the decision in GISKS, GISKS, Gisks and the owners of Strata Plan 6743. And that was actually proceedings brought by a lot owner against one of his fellow occupants within the Strata scheme, asking the tribunal for orders to stop that first lot owner from smoking within the Strata scheme. And it was an interesting argument which the non-smoking lot owner brought. He said that the smoke drift which was occurring and coming into his apartment was a nuisance, and therefore in breach of what is section 153 in the New South Wales legislation, which says you can't use a lot in a manner which causes a nuisance or hazard to other lot owners. Now, two things come out of that decision. The first is that the tribunal accepted that smoke drift, smoke penetrating into other lots, is a hazard, is a nuisance to other lot owners. And they said to the smoking lot owner, you can only smoke inside your lot with all the windows and doors closed. But if there was to be any smoke penetration to common property or to other lots, then that will be behaviour which we can make orders about under section 153. So, I mean, I regularly visit strata blocks, and sometimes as you walk up the stairs, you can tell that there's somebody smoking in the building because smoke doesn't stay behind a door. It comes under the door or through the door jambs or out windows. And I think that it's going to be a more common thing for owners' corporations to crack down on that, because living in strata is about, you know, give and take. It's about living in community and living but not interfering with other people's rights and enjoyment of living. And whereas in the past people may have put up with smoking, I can see that owners' corporations and lot owners are becoming increasingly militant about cracking down on smoking in strata. Not within lots necessarily, but where the smoke escapes and other people have to encounter it, then it's going to become increasingly difficult. So to get back to your question, whilst smoking's not banned in strata, people still have the right to smoke. I think that the reality is that owners' corporations, with these couple of decisions, have an increasing number of tools with which they can tackle that issue.
And have any changes been made to the legislation? Because I know our readers will be interested in that. So based on this decision, has it actually formed part of the legislation, or do you think it will be forming part of the legislation in the future?
In the changes which were made to the strata legislation in New South Wales last year, part of that was to implement a new set of standard or model bylaws for owners' corporations. And one of the bylaws within that set of model bylaws has a beefed up, if I can use that description, bylaw in relation to smoking and in relation to the control of smoking, so that the one which was under discussion in the first case that I was talking to you about, that was, you know, a very basic kind of bylaw saying you can't smoke on common property or to allow it to penetrate common property. The new model bylaw gives the owners' corporation additional tools. I mean, I should say that the new model bylaw still probably doesn't go as far as it could in relation to enabling owners' corporations to control the issue of smoking, but it is an extra step and signals an intention on behalf of the Parliament to bring smoking more under control within a strata context.
Okay, so if I'm a lot owner and I'm living in an apartment building and I'm a smoker and I'm thinking that I'm fine to smoke within my lot, can the owners' corporation do anything to stop that, or what should I be concerned about moving into the future?
Well, harking back to the two cases I've been referring to, if you smoke within your lot and that smoke stays completely within your lot and doesn't escape out into the corridors, the stairways, or through the airspace into your next door neighbour's lot, then you should be okay. I don't think the strata could stop you. You may be poisoning yourself, but that's an argument for somebody else to have. If you do something within your lot and it doesn't interfere with anybody else in the strata scheme, then you're okay. But if the smoke escapes into common areas and someone objects to that, or if the smoke escapes and travels through the airspace and goes into your neighbour's lot, then you're likely to face some difficulties.
So just thinking out of it from a broader point of view with the owners corporations, what is the guiding principles that owners corporations need to think about now when they're considering a bylaw dealing with the issues of smoking, and should they be considering a new bylaw at this point?
Look, I think owners corporations should be considering a new bylaw because, as I said, even though the bylaws, the model bylaws have been updated with the legislative changes in 2021, the Parliament's always a little bit behind where the rest of the world is in relation to dealing with things. So, for example, if we're drafting bylaws in relation to smoking, we ask owners corporations to think about matters like vaping and electronic cigarettes. Now, they are hot current issues in relation to that sort of area. You know, I've seen bylaws that talk about people smoking pipes and cigars, and you know, they are things of the past in a sense. The things of the future are e-cigarettes and vaping, and the owners corporation needs to think about how they want to treat those and how they want to deal with them in the sense of a bylaw. Do they want to treat them in the same way, or are they prepared to kind of allow those sorts of things as an alternative? Also, there's often a lot of paraphernalia and waste which is generated by these new ways of smoking. Little canisters and cartridges. And if you're talking about traditional smoking, you've still got matches and ash and all those sorts of things. Do owners corporations want to deal with that specifically in a bylaw to make the depositing of that sort of rubbish on common property to be a breach of the bylaw? Sometimes owners corporations set up specific smoking areas. So down in the back corner, against the fence, you're allowed to smoke, or you know, down near the road, against the front fence, you're allowed to smoke, but nowhere else. These are the things which owners corporations need to balance, because the guiding principles for owners corporations are: how can we allow lot owners to live communally as they do in a strata scheme, and to do so without infringing upon each other's rights? So I want to be able to exercise my rights as a smoker. What the owners corporation is to think about: how can we allow you to do that in a way which doesn't interfere with other lot owners within the scheme, which doesn't create a hazard for them, which doesn't create a nuisance for them? So they're the sorts of things owners corporations can think creatively about, and we certainly have thought about those issues, and so we can give them some guidance in relation to drafting and bylaws which suit their particular circumstances. I mean, creating a smoking area within a scheme doesn't always work, because some schemes just don't have an appropriate spot, which still won't interfere with other lot owners and occupiers. Some do. So you need to look at those sorts of things on a case-by-case basis.
And now it's a good time to sort of have that conversation within the owners corporation and maybe review what bylaw you've got, and possibly have a talk to somebody like yourself to review that and see what they need to do moving forward. That's
right. And you know, if owners corporations are thinking about cracking down or trying to at least be more specific in relation to the problem of smoking or the question of smoking within their scheme, they also need to look sort of more broadly at what, as a next step, they would do if they had to deal with a smoker. Does their bylaw allow them to seek a penalty, for example, in NCAT? Do they just want to seek orders for that smoking to stop? What are the bylaws within their current bylaws which would allow them to control and regulate that issue? So yeah, that definitely is a timely matter to consider within schemes.
And be a bit proactive about the situation rather than waiting for the problem to develop.
Absolutely, because my experience is that it, if allowed to go unchecked, is a source of disharmony and unhappiness, and I guess none of us want that within our strata schemes.
Definitely not, definitely not. Okay, that's wonderful. Thanks so much, Warwick, for giving us that overview. It certainly gives us a lot more detail about the case than we were able to provide in the article that we've shared with our audience. We'll link to the article below the video so that people can go back if they maybe refresh it. I'm sure a lot of our audience has read it. It's had amazing numbers of viewers have actually read the article to date, but this will refresh their memory of the article that you wrote, and also sort of give a bit more context to this discussion that we've had. So thanks very much for joining us today.
You're really welcome.
That's great. And then if our viewers have any questions about smoking in New South Wales strata buildings, they're looking at updating their smoking bylaws, as we've just talked about, which is not a bad idea at this point in time. And also, if you have questions about what this case may mean specifically for you in your strata scheme, please either leave a comment below this video or get in touch with Warwick and the team at JS Mueller Co Lawyers. I'll provide Warwick's contact details below the video so that you can always contact him for a chat. And thanks very much for joining us.
Thanks, Nikki.